quando você compartilha, não é um aviso, quando você compartilha, fica um aviso que a gente vai voltar. Eu não vou ouvir sobre isso.
Com cuidado e responsabilidade, a PUC Goiás ampliou as atividades acadêmicas presenciais no último semestre. Seguindo as orientações das autoridades, a universidade realizou com segurança todas as atividades acadêmicas e administrativas permitidas. A universidade recebeu com alegria os resultados do levantamento realizado em dezembro de 2021 pela Pró-Reitoria de Graduação, que mostra que 97% dos estudantes estão imunizados com a primeira dose da vacina contra a Covid-19. A pesquisa também indica que 78% dos alunos estão totalmente imunizados com 2 doses da vacina. Confirmando seu compromisso com a ciência e com a vida, a instituição participou das campanhas vacinais e testagens, prestou atendimento gratuito à comunidade na área de reabilitação pós-Covid e esteve na linha de frente das pesquisas que visam o controle e enfrentamento da pandemia no estado de Goiás. A pandemia permitiu novas formas de experiência internacional, conectando pessoas com o mundo afora por meio das plataformas digitais. No último semestre, a universidade promoveu lives com pesquisadores de outros países e desenvolveu pesquisas em rede com universidades estrangeiras.
Os desafios da pandemia foram inúmeros, as aprendizagens foram imensas. Eu creio que talvez a maior delas, inclusive para a própria gestão educacional, foi a inserção no cotidiano da nossa vida, já a incorporação de tecnologias. Eu creio que entre nós, professores, especialmente da minha área, que era a área da educação, sempre uma certa reserva crítica em relação ao uso das tecnologias como mediadoras do processo ensino-aprendizagem. Não tenho dúvida que esses 2 anos, forçosamente, todos os professores que gostavam ou não, que acessavam ou não a tecnologia, tiveram que necessariamente mudar de posição, não é? E creio que a mudança é sempre possibilidade de crescimento.
De olho nas demandas do mundo do trabalho, a PUC Goiás ofertou cursos de graduação nas modalidades presencial e à distância, nas mais diversas áreas do conhecimento, com o diferencial formativo que só uma universidade proporciona. A PUC também implantou sua nova configuração, agora composta em 5 escolas, que abrigam os cursos de graduação e pós-graduação da universidade. O segundo semestre foi marcado pela consolidação dos cursos de Medicina Veterinária e Odontologia, lançados em 2018 e 2020, respectivamente. Novos espaços foram inaugurados e apresentados à comunidade acadêmica, reforçando o compromisso da instituição de promover uma aprendizagem qualificada com infraestrutura de excelência. Unidades administrativas também estão de cara nova. A 8ª edição do Prêmio Mérito Acadêmico foi uma solenidade de muita emoção. Formandos dos cursos presenciais e à distância foram reconhecidos pelo êxito nos estudos. Com o objetivo de promover a inserção dos estudantes e egressos do mundo do trabalho, a PUC firmou novos convênios de estágio, abriu seleções para monitores e movimentou a programação acadêmica com a realização de 2 edições da Feira do Emprego durante o mês de novembro. Na ocasião, milhares de vagas foram ofertadas à comunidade acadêmica e à sociedade em geral. Sempre em diálogo com a sociedade, a instituição firmou ao longo do semestre diversas parcerias para promover a educação e a inclusão social, reafirmando seu compromisso com a missão educativa. A pós-graduação Lato Sensu, que oferece cursos de especialização presenciais e à distância em todas as áreas, está de casa nova. Por aqui, o estudante encontra o caminho para se tornar um profissional completo.
A pós-graduação Lato Sensu da PUC Goiás preparou 4 novas modalidades de cursos: cursos presenciais, cursos semipresenciais, cursos online ao vivo, cursos em EAD. E o balanço que a gente faz da pós-graduação Lato Sensu da PUC Goiás em 2021 foi bastante positivo. Tivemos a abertura de 27 novos cursos nas várias áreas do conhecimento, totalizando mais de 1.280 alunos matriculados no ano de 2021.
Os programas de pós-graduação estrito sensu também apresentaram novidades. Novos gestores assumiram as coordenações dos cursos de mestrado e doutorado com a missão de incentivar a interdisciplinariedade dos programas, buscar novas parcerias, editais de financiamento e ampliar o número de estudantes e de projetos em conjunto com outras instituições. Com foco na produção e difusão do conhecimento científico, a PUC Goiás promoveu em outubro o 7º Congresso de Ciência, Tecnologia e Inovação. A universidade premiou as melhores pesquisas produzidas em diversas categorias e anunciou os acadêmicos vencedores das Olimpíadas de Cálculo e de Química, do Desafio de Dados e do Hackathon PUC, lançados durante o evento. A docente da Escola Politécnica Marta Pereira da Luz foi homenageada com o título de Mérito Científico, que reconhece as contribuições científicas dos pesquisadores e pesquisadoras para o desenvolvimento da ciência no Brasil e no mundo. A Jornada da Cidadania retornou ao calendário da PUC e da comunidade goiana, em outubro. Com atendimentos híbridos à distância e presenciais, a universidade ofereceu serviços gratuitos nas áreas de educação, saúde, justiça, empreendedorismo e cultura. Ainda com a missão de promover a consciência cidadã e o acesso à arte e à cultura, a instituição ofereceu oficinas culturais gratuitas à comunidade, no formato remoto ao longo do semestre. A Escola de Circo Dom Fernando e a Escola de Formação da Juventude retomaram sua agenda de atividades presenciais. Agora, em nova sede, a Escola de Circo acolheu os novos educandos da região noroeste da capital no último mês de novembro. Devido à situação de vulnerabilidade vivenciada pela população de baixa renda neste contexto de pandemia, a instituição também promoveu campanhas solidárias e prestou atendimento à comunidade por meio dos seus programas e projetos da extensão. Coerente com sua natureza filantrópica e comunitária, a universidade incentivou o ingresso e a permanência de estudantes de baixa renda no ensino superior. No segundo semestre de 2021, a instituição registrou mais de 8.000 acadêmicos beneficiados em programas de bolsas e financiamentos. Por fim, a extensão encerrou o semestre com uma novidade importante para toda a comunidade: o Memorial do Cerrado, museu antropológico a céu aberto, onde pulsa a origem do Cerrado e da cultura goiana, foi reaberto para visitação do público. Fechado desde março de 2020 por causa da pandemia da Covid-19, o museu segue as normas de biossegurança para acolher os visitantes. A dedicação diária da PUC Goiás à educação e à transformação da sociedade goiana foi reconhecida pelo Prêmio Poplist 2021, realizado pelo jornal O Popular. A marca da instituição foi a mais lembrada por 51,6% dos goianos na categoria Universidade Particular. Reconhecimento também na graduação. O Prêmio IEL de Estágio foi para estudante do curso de jornalismo, Joyce Nune Vilela Merri, que conquistou o primeiro lugar na categoria Projetos Inovadores.
O Prêmio IEL Goiás significou para mim um reconhecimento de todo um processo de 4 anos do curso de jornalismo, em que envolveu a teoria aliado à prática.
Em novembro, a instituição reconheceu a trajetória dos egressos que foram além do seu dever profissional e atuam como difusores da transformação social nos lugares por onde passam. No último semestre, a PUC Goiás participou dos preparativos da 16ª Assembleia Geral do Sínodo dos Bispos, que ocorrerá em outubro de 2023. Convocada pelo Papa Francisco, o tema abordado será Por uma Igreja Sinodal, Comunhão, Participação e Missão. Em novembro, a Igreja Católica em Goiânia conheceu seu novo arcebispo, Dom João Justino de Medeiros Silva, até então arcebispo de Montes Claros, em Minas Gerais. Dom Washington, que apresentou renúncia por limite de idade em maio do ano passado, entrega a missão ao seu sucessor após 19 anos à frente da Arquidiocese de Goiânia. Foram quase 2 décadas de dedicação e participação efetiva na história da PUC Goiás, onde seu legado será lembrado pela serenidade, cuidado e firmeza, respeito, diálogo e presença na SGC e no Vicariato de Educação. Gratidão, Dom Washington. Bem-vindo, Dom João Justino.
Querido irmão, querida irmã, desejo que o infinito e perfeito amor, que é o próprio Deus, esteja em cada um dos senhores e das senhoras que dedicam suas vidas em prol da missão educativa da nossa universidade. Como pastor da Arquidiocese de Goiânia, acompanhei nos últimos 20 anos os acontecimentos que marcaram a sua rotina acadêmica e administrativa, suas conquistas e os desafios superados com empenho e criatividade. Por ser de Cristo e de sua Igreja, a PUC Goiás é portadora de uma missão imensa. Somos guardiões do rico e profundo conhecimento humano produzido ao longo dos tempos, que conduz homens e mulheres ao encontro de Deus. Manifesto minha estima e gratidão a todos aqueles que participaram e atuam na missão evangelizadora na própria universidade e em toda a Arquidiocese de Goiânia, desde a sua fundação aos tempos atuais. Lembrem-se que a ação cristã no mundo deve ser planejada com uma contribuição para uma civilização do amor, da fraternidade, da solidariedade e da paz. Com a mesma confiança, olhem agora para o futuro da nossa universidade, sob a orientação e direção do novo arcebispo e grão-chanceler, meu irmão na missão, Dom João Justino de Medeiros Silva. Abençoe-vos o Deus Todo-Poderoso, Pai, Filho e Espírito Santo. Fiquem com Deus. Nossa Senhora Auxiliadora, rogai por nós.
Bem, boa noite a todos. Gostaria de agradecer a presença de todos vocês aqui nessa noite para o nosso primeiro webinário internacional em parceria com a Universidade de Dayton, Ohio, nos Estados Unidos. Agradecendo a presença de todos vocês, quero agradecer também especialmente a presença dos representantes da Universidade de Ohio, né? Lori Eisenberg, Walter Ross, professor Chris Roderick, o palestrante dessa noite, e a estudante brasileira, a primeira graduada na Escola de Direito de Dayton, Mônica Reis, que vai falar um pouquinho da experiência dela para vocês, mais ao final da palestra. Então, pessoal, é uma noite muito, muito especial. Meu nome é Paulo Gonzaga, sou professor de administração aí da nossa Escola de Direito, Negócios e Comunicação e sou responsável pela assessoria de Relações Internacionais da PUC Goiás. Então, essa é uma oportunidade muito boa para vocês, nossos alunos de Direito, porque o ano passado nós fizemos uma parceria com a Universidade de Dayton, né? E essa parceria traz grandes benefícios para vocês aí. Mestrado em Direito Online, o Walter vai explicar tudo isso aí ao final para vocês. Vamos deixar os nossos contatos para vocês tirarem as dúvidas, mas vocês podem fazer um mestrado de Direito numa universidade americana e, concluindo esse mestrado, vocês podem prestar o exame da ordem né, ou do estado da Califórnia ou do estado de Washington, podendo exercer a profissão nos Estados Unidos. Inclusive, Mônica vai falar sobre essa experiência dela. Então, uma oportunidade única, e esses webinários que nós estamos realizando desde o semestre passado, né, é para deixar você inteirado com os tópicos, com os professores, que quem sabe no futuro bem próximo serão seus professores lá nos Estados Unidos. Então, gostaria agora, primeiramente, então, meus queridos, dar uma breve descrição do nosso palestrante de hoje, professor Chris Roderer, e ele é um pesquisador, né? E o foco das suas pesquisas é em direito comparativo e direito constitucional, com foco na interseção entre o direito constitucional, democracia, direito privado, através de delitos, contratos, propriedade, né? E o direito em geral. Antes de ser um professor na Universidade de Dayton, o professor Roderer ensinou em várias universidades dentro dos Estados Unidos e também em universidades na África do Sul, Papua Nova Guiné e na República Tcheca. E durante, né, o seu curso de Direito, o professor Roderer também foi editor, né, do Jornal de Direito da Universidade de Nova York. O professor Roderer já publicou vários livros, capítulos de livros e vários artigos relacionados ao direito. Ele se formou em Direito na Universidade de Kansas, em 1989, obteve o seu mestrado na Universidade de Texas, em Austin, em 1994, e o seu doutorado em 1992, na Universidade de Nova York, a Escola de Direito da Universidade de Nova York. Professor Roderer, we are so glad to have you here tonight, and I'm positive that we have a lot to learn from you and your presentation tonight. Please, Professor Roderer, the platform is yours.
All right, thank you. Good evening. So I think my colleague is going to put up the slides now. Is that right? All right. And so tonight, or this afternoon, depending upon your time zone, I suppose, I'm going to talk about a few current issues in United States constitutional law. In particular, I'm going to talk about a couple of controversial issues. They're before the Supreme Court at this point in time, with relation to gun rights and with relation to reproductive rights or the abortion issue. These have been contentious issues for probably the last 100 years, if not the last 200 years or more within the United States. President Trump, when he was elected, he made a point of saying that he will appoint pro-life conservative Second Amendment judges and judges who will interpret the Constitution the way the founders, our founding fathers, wanted it interpreted. And so, consistent, I suppose, with that tradition of politicizing these issues, right? The president sort of sought to appoint, and he did appoint 3 justices to the court. And I think he appointed several justices throughout the federal system in the hopes that this would change the court's trajectory and in the way the court was going to interpret and apply the Constitution, right? Unfortunately, during most of this period, the American public's confidence, which had historically been fairly high for the U.S. Supreme Court, has diminished. And lots of people now consider the Supreme Court to be political, right? In other words, that it's not interpreting the Constitution faithfully. Now, people disagree significantly about what it would mean to interpret our Constitution in a way that wasn't political, that was based in some ways on neutral principles. Some people believe that if you read the text and you look at what the founding fathers would have thought, that is the way to political neutrality. And that's what President Trump, I suppose, was attempting here. Others do not see that as being politically neutral. And the cases that I'm going to talk about today and the history of those cases, I think will point up the sort of, to some extent, hypocrisy, perhaps on both sides, as to what the text would require and or what our founding fathers might have envisioned by the respective rights in question, right? There's in some ways a battle for what rights are part of our deeply held values, part of our history and tradition in the United States. And so we just move on to the next slide. I'll start with the Second Amendment, right? So the text of our Second Amendment to our U.S. Constitution, which was designed initially to bind the federal government. In other words, the Second Amendment was addressed to our federal Congress, our president, and our legislature, and basically what it says, right? A well-regulated militia being necessary to the security of a free state, the rights of the people to bear and keep arms shall not be infringed. So what does that mean? Well, for a lot of our nation's history, we disagreed about that meaning, but the court was actually very consistent in interpreting that meaning, from the district courts to the federal circuit courts and up to the Supreme Court, that provision only applied to the federal government, and that provision did not produce an individual right to a gun unless you were part of that well-rounded or well-regulated militia. And so what is a well-regulated militia? It is, in fact, what has become our National Guard. These were people within states who were regulated by their states, trained by their states, and who were allowed to have guns so that you could pull up those militias, right? And so in some ways, right, this right that people have asserted to have a gun is not a right that finds itself very easily within the text of this Second Amendment. And it doesn't find itself to be one that has been recognized in the United States since the time of the founding, right? And so if we go to the next slide, there's an argument that while the text of the Second Amendment and the founding fathers' view of that Second Amendment didn't provide a right to keep and bear arms for self-defense, in other words, an individual right, some people like myself think, well, it's probably a right that's more deeply rooted in our history and tradition and maybe even predates the Constitution. In other words, it can be found in the Ninth Amendment, right? And our founding fathers, when they drafted the Constitution, were concerned that if we enumerated or listed those first rights in our Bill of Rights, that people may take that to imply that if you're not on the list, those rights don't exist. And in fact, there's a lot of rights that the Supreme Court has recognized that aren't found in that text, that they have found to be deeply rooted in our history and tradition. Now, they tend not to refer to this Ninth Amendment provision, but I'll give you an example of some of those rights that are deeply rooted in our history and tradition. They include things like the rights of parents to raise their children, right? The rights to marry are also seen to be those fundamental rights that are deeply rooted in our history and tradition, even though those aren't listed in the actual constitutional text. And so if we go to the next slide, we'll see that the Supreme Court changed their view of that Second Amendment right, which up until 2008, in other words, for our nation's 219 first years, the court had not recognized that there was an individual right to have a gun. But in this case, involving a Washington, D.C. law that basically meant if you had a gun, you could have it in your home, but you had to have it in such a state that you really couldn't use it if someone broke into your house. You had to have it locked and secured. And the court here found that, in fact, there was this right to keep a gun, an individual right. They didn't root it in that Ninth Amendment idea of it being out there deeply rooted in our history and tradition. But it was the conservative side of the court here, right? It's the mainly Republican appointed judges who tend to believe in the text of the Constitution. They're the ones that decided that now, after 219 years, they would discover that this right exists and that it was in some ways in that Second Amendment all along, right? And so if we move to the next slide, the court basically held that first part, right, that first part that the courts had held for, the last 200 years, really made it a right that you only had as part of that militia. That part was not to be read as an actual literal part of the Constitution, right? It was just kind of throwaway text that we can ignore. And so the right is not one that's just for people who are in a militia. But in fact, there is somehow in that text, even though the text says nothing about this, a right for self-defense in the home, right? And so the court says you have a right to have a gun in the home for self-defense. That's what this court finally decides that Second Amendment requires. Now, at the same time, if we move to the next slide, you can see the Supreme Court said, but it doesn't include all these things. So there's no right to have a concealed weapon, so no right to a sawed-off shotgun, no right for people who are mentally ill or who are felons to have a gun, no right to have a gun in sensitive places like schools or government buildings or the Supreme Court room, right? And that, the right to sell and buy guns could be limited by Congress under its Commerce Clause powers. Right? There was also this idea that you shouldn't be able to have unusual or dangerous weapons, right? So even though the founders thought you should have a gun as part of a well-regulated militia to be enabled to defend the country, right? The court here says, well, that doesn't mean that your individual right to a gun means you get to have, a fully automatic machine gun or a anti-aircraft, missile launcher or an airplane or any of these other things. And so where would one find all this in the text of the Constitution? It's actually not in there, right? And so conservative justices in this case really effectively sort of created a right that they found sort of roughly in that Second Amendment text, and then created a list of exceptions to that right at the same time that were based on all the cases that had come before, which had found that there in fact was not a right, right? And so it's a somewhat peculiar case. And if we move to the next slide, we see that the development of the law then in 2010 takes even a further step, right? So in 2008, the court had decided that this was a right that individuals had against the federal government, right? Because that's what the original Constitution and the original Second Amendment would have applied to, if anything. But in McDonald v. City of Chicago, the court decided that this provision would also apply to the states, so that states and cities also could not infringe upon your right to have a gun, right? Now, this case, I mean, it's a little bit esoteric based on, in some ways, the American system in the process of incorporating rights and making them apply to the states. But here, the text of the Constitution itself seems to indicate that you would be part of a state's militia that was well regulated, and that you would be well regulated by the state and or by the federal government. And so it was a bit of a stretch to move it from a right against the federal government, given the text, to a right against the states. But nonetheless, the court again in McDonald extended that right. And so if we move to the next slide, you can see the reasoning behind that. They basically again say individual self-defense is the central component of that Second Amendment right, right? And because it's this basic right, recognized by many legal systems from ancient times to the present day, people now have this individual right to have a gun for possession in the home, right? And so the thing that's somewhat remarkable about this is that this is a right that conservative members of the court that have tended in the past to argue that it's the text of the Constitution that should matter, they shouldn't be creating or discovering new rights, somehow find this right that's deeply rooted in our history and tradition, but was never recognized for the first 200 years of our history, right? So it is somewhat peculiar. So at this present time, if we go to the next slide, there is a case that's now trying to extend that right once again and extend it even further, right? So those previous cases said, really, you only have a right to have a gun in your home for protection, for self-defense. There's nothing about those cases that say you have a right to carry a gun in public, much less a right to concealed carry a gun in public. But states throughout the United States, some of them allow that, some of them forbid it. And New York had this law, it's been on the books for over 100 years, basically said that if you want to have a gun in public and you want to conceal it, right, you're going to have to show a special need to have that gun. And so what people here are trying to achieve is a general right for Americans not only to have a gun in the home, but a right basically to carry a gun with you and to conceal that gun anywhere you go in America, right? Obviously, given, the controversial nature of, public shootings, mass shootings in schools and so on in America, it's generally people on the left that have been asking for more gun control and less guns, right? But here again, the hope of people bringing this claim is that the Supreme Court will not only yet again, endorse this right to a gun, which started out arguably as a right to a gun for self-defense in the home, and extend that out to a general right for every American to have a concealed weapon in public. And so that's sort of the case that's coming up that the left side of the court will probably oppose. Maybe the right side of the court will support. We'll have to see. The conservatives in America, the Republican voters generally will support those who want a broader gun right. Liberals, Democrats, and so on tend to want more gun control, right? So it's a very hot political topic. But the deeper and more persistent political topic is really the next one that I'll address here, which is reproductive rights. And so if we move to the next screen, this is maybe a somewhat offensive slide. It has both the sort of celebrate human life and the sort of celebrate choice, right? Abortion is a deeply personal, moral, difficult issue, but it is also a constitutional issue in the United States. And it was constitutionalized back in 1973. So the pedigree of this right, even though it's not listed in the Constitution either, dates back, now about 50 years ago or more, or right around 50 years ago. And it started in this case of Roe v. Wade, if we go to the next slide. And so basically, in Roe v. Wade, in the next slide here, we see that the court recognizes that women have a right to choose. Where does this right to choose or this right to privacy come up in our Constitution? Well, it partly came from previous decisions that the court had made, and partly from this idea that the constitutional text includes a number of provisions that secure our privacy from government invasion, right? We're supposed to be free from unreasonable searches and seizures. We're supposed to have freedom of conscience and belief and religion. We're supposed to be free from soldiers being quartered in our homes. And so there is this idea that we should have some space in which we operate, which is private. And the court had previously recognized a right to have contraception and to choose whether or not to have, those contraception pills. They also decided you had a right to conceive if you wanted to. In other words, a right not to be sterilized. And so the next step here was the right of a woman to choose. And the court had broke it up into these 3 trimesters to make it very clear that in the first 3 months or so, the choice was really fully up to the woman, and the state really could not intervene. In that middle period, that middle 3 months, the state could come in to try to regulate, to make facilities healthier and more safe for abortions if that was the person's choice. And in that 3rd trimester, when it was thought that a fetus would be viable, the court recognized there the state had a compelling interest to regulate and or ban abortions altogether, as long as there was an exception that allowed for the health and or life of the mother to be protected. And so if we move on to the next slide, we see that there was a huge change between 1973 and 1993, right? So that in that period of time, you had a radically different court, right? Most of the people that had voted for Roe v. Wade had left the court. And between 73 and 93, lots of appointments to the court were based on, in much the same way that Trump's appointments were, based on a promise that these people would be appointed who would overturn Roe v. Wade, that would turn back the clock and not recognize this right. And so by the time you get to 93, basically you've got a very significantly Republican-dominated court filled with justices who did not believe that this was a fundamental right. So if we go to the next slide, you have the decision that comes down in that year, the Casey decision. And here the court, and particularly Justice O'Connor on the court, who was a Catholic, who was pro-life, and I think in her personal views would not be pro-choice. Yet in her decision, she said, we cannot overrule Roe v. Wade, right? We have to uphold that essential holding of Roe, largely because women have come to depend upon this right. And I think largely because she did not want to be perceived, and she did not want the court to be perceived as simply a political court, that the judges being appointed by conservative or Republican presidents who promised to overturn Roe v. Wade, right? They wanted to separate themselves from that appointment process. They wanted to be clear that they were not political actors, but that they were following precedent, right? And precedent that had established certain expectations and reliance on the part of women. And so they changed the standard fairly significantly in Casey. So they in some ways made the right not as strong, but they still upheld the right for a woman to choose. And at this point, they switched from this trimester approach really to an approach that looked at whether the government had put a substantial obstacle in the way of a woman to choose before that point of viability, or whether they really unduly burdened her right to be able to choose before that point of viability, right? They still recognized that at the point of viability, now instead of the 3rd trimester, that there would be a compelling interest in that life of the child at that point. But before that point, they really shifted to look at whether the laws that were being passed really made it too onerous for a woman to exercise her right. And so if we go to the next screen, the court dealt with a number of things, right? The things in red are the things they got rid of. So in other words, they got rid of trimesters. They changed the law. They said the law that said you could only have an exception for the health of the mother if it was death or serious risk of substantial and irreversible impairment of a major bodily function. They said that's too difficult a standard, right? You have to have a standard that allows for a woman whose health is in jeopardy to choose to make that choice, even if you're not going to have death or serious, substantial and irreversible impairment. But they did say it was constitutional to require people to be informed, to have a 24-hour waiting period before you actually have the abortion. And for children, they required parental consent, as long as there could be a way for a child who was in danger to have a judicial bypass. They allowed for record keeping. But there was another provision that they thought was a substantial obstacle, and that is basically the requirement that a woman get permission from her husband, from her spouse. And the court thought that was too onerous and was too dangerous in a situation where a woman was making that choice. And so, contrary to popular belief, even though politicians, presidents stacked the court with people that are going to overturn the right, this was a classic case of the court, the majority of those appointments saying, we're not political actors, we're going to follow precedent, and we're going to uphold this right. Now, fast forward to the next slide, and several decades later, people are still passing laws trying to restrict the rights of women to exercise this choice. And in this Texas case, you have a fairly broad law that arguably on its face was designed to make abortion facilities safer, to make them better places for women to go to. In other words, better services, access to hospitals and everything else. But those who supported women's right to choose felt that this law was really not actually designed to help women have safer, more effective, less risky abortions, but to shut down clinics, right? By requiring such high standards of clinics and by requiring these very onerous, requirements that they have visitation rights at hospitals and that they be basically the equivalent of an ambulatory emergency room service, they were going to shut down tons and tons of these clinics in the state of Texas. So if we go to the next slide, you can see the sort of right and how it's being burdened here. Basically, they had already imposed the one provision, and that basically meant that half of the facilities were closed. So when they required these really high standards for the facilities, over half of them already closed down. Now, with the second set of things requiring that you be able to be admitted to a hospital, that was going to shut down even more of them, right? So you're going to go from 40 down to 20, down to 7. And that meant effectively that each facility would be having to serve between 7,000 and 10,000 patients in each of those facilities per year, which meant very long distances, very long wait periods. And so that was going to be very problematic. And so even though in the interim, you had a lot of people being appointed to the court that, again, were thought to be anti, Roe v. Wade, and were thought to be interested in overturning Roe v. Wade, they upheld that central holding. They upheld the Casey decision and decided that this was a substantial burden. So if we go to the next slide, we see yet again another change, right? From 2016 to 2020, the picture changes again, right? And so, right, there's another case, another law, and in fact, the state of Louisiana passes effectively the same exact law that was passed in Texas, where the court had already said this is an unconstitutional burden on women. And so why would they do that, right? They know it's unconstitutional. They know the Supreme Court has already decided this. But again, you have the situation where, if we hit the next animation, we see that Kennedy's no longer there, right? You have the addition of Justice Alito, you have Kavanaugh, you have Gorsuch. And so you have some big changes on the court, right? And so there was a hope, again, that this change in the composition of the court with the addition of more conservative justices would result in that political decision that everybody wanted who supported that, and they would overturn Roe v. Wade. So if we go to the next slide, we see that effectively, and we pull this up, Louisiana does the same exact law, right? And that's sort of the history from the one law to the next. So now Louisiana is trying it, hoping for a different result. And Justice Roberts basically says, no, we already decided this, right? We've already decided this. This is an unconstitutional burden on women. And so, again, they strike down the Louisiana statute, right? And so, interestingly, again, it's majority, right? A number of the conservative justices joined the dissent, but enough of the conservative justices join with the liberal justices to strike down these laws, even though they would have preferred to have them upheld and for the constitutional right of, choice to be found to be unconstitutional. So it's an interesting dynamic. Now, the most recent case that was decided, if we go to the next slide, is actually a case that was decided under COVID. And this case does signal perhaps that a court might come out differently in future cases, and in particular in the cases that are before the court now. And that is that a lot of abortions in America are effectively performed by taking what's sometimes called the day after pill. You take a medicine, shortly after conception, and basically it acts as an abortionogenic. And there's something unique about that in our system. It is the only drug that you have to, in fact, go to the doctor and get. Most other drugs, you go to the doctor then prescribes it. You go and pick up that from the pharmacy. And under COVID, many of those doctor's appointments could be via video. But the FDA didn't change its rules. And during COVID, women were required to go into doctor's offices, even if they're pregnant and people might have COVID, and they would be then exposed and have a higher grade of risk. And so a district court actually enjoined that rule and said that women no longer during the COVID pandemic would need to go in. So this was a lower district court that actually had said that this would create an undue burden. So if we go to the next slide, this doesn't look exactly as I hoped. So Roberts, the majority opinion should be on the left. The dissenting opinion is on the right, but they're a little bit too big, so they ended up on the next line. But the text on your left is what the Chief Justice said. The text on the right is what the dissent of Sotomayor said, right? And so basically the distinction here between the majority and the dissent, the majority of the court following Chief Justice Roberts basically said you can't stop the Federal Drug Administration from having or requiring that women go in person and obtain this drug, and that the court was not correct to decide that this was an undue burden. And that for Roberts, that choice of whether or not this would really burden women or whether this was important for them to come in and get the drug in person, that was a choice for the Food and Drug Administration, not for the courts, right? And so that signals that the courts maybe will defer to the judgment here of Food and Drug Administration, but maybe in the future cases coming up to a determination by the state legislature, right? Sotomayor on the right said this is really kind of ridiculous, that there is a heavy burden to show that in fact there was not this substantial obstacle or undue burden in the path of the woman's right to choose. And so the next slide will give you a couple of cases that are coming up. The Texas abortion law is a very peculiar strategy in the United States. Basically, it's a law that bans all abortions in the state of Texas once cardiac activity can be detected, and that's basically the 6th week. So very early on, right? A lot of people don't even know that they're pregnant, 4th, 5th, 6th weeks, sometimes until later. And so basically it's seen as almost a complete ban. And so the unique thing about this Texas law, unlike those other laws, it's not about health standards or about facilities. It's really a law that allows private citizens, right, you and me or anybody else, to bring a private lawsuit against anybody that is trying to aid or abet or have or provide an abortion after that cardiac activity, after that heartbeat is detected. And so the problem with that law, and people have tried to bring their case to the federal courts, and they have said, well, you don't have standing because no one has sued you, because the state of Texas doesn't actually enforce the law as a criminal law, like as in the case of most of these other abortion laws. So this case has kind of stalled and hasn't been able to be decided. And so in the meantime, right, the claim by women within Texas is that effectively all abortions are banned until we can actually get a case before the court. So this one, it's hard to know when it's going to get up to the Supreme Court. Now, in the meantime, there's another law and a set of laws like this across the United States. If we go to the next slide, in Mississippi, they have now a law that basically bans abortions at the point of 15 weeks, right? Now, the thing about that particular law is that, it's generally considered that viability for a fetus at this point in time with our medical developments doesn't happen until about 24 weeks. And so this would be a law that was clearly contrary to the decision that was made in the Casey case in 1993, and which has been upheld as good law ever since. And so again, here it's Mississippi trying to change that from the 24-week period, which is probably about where viability is, down to the 15-week period. And so, one somewhat interesting aspect to all this is that if the court does decide to strike down Casey and uphold this Mississippi abortion law, there's a bunch of states that already have laws that have been signed into law in their states and are just waiting to be activated if, in fact, the Supreme Court overrules Roe v. Wade. And so if we go to the next slide, it's basically how's the court going to decide? And it's really difficult to tell, right? People have been predicting for the last, 50 years almost that the Supreme Court is going to overturn Roe v. Wade. But, from that period of Casey all the way to today, right now, about 30 years, the court has consistently said, no, we are not going to overturn our Casey decision. You still cannot put a substantial obstacle in the way of a woman's right to choose. Now, there's a lot of members on the court that have that sense, right, that they have been put on that court for political reasons, and they understand that the American public perhaps thinks that they may make decisions that are based on politics. And I think that may, if anything, impact, whether or not they ultimately overturn that decision of Roe v. Wade and or the Casey decision. But it's really very difficult to tell. There's no question that at least 7 members of the court think that those initial decisions were wrong and that there should not be a right to choose for women, right? But that view, that precedent was wrong, really then butts up against the fact that we have had now over 50 years of history and tradition of recognizing this right. So in some ways, that right to choose, that liberal right that some people think is a right that leftist people or Democrats tend to celebrate, right? Even though they think it's a made-up right, it's still a right that's been around longer than that right to own a gun. And so you really have this sort of clash between those rights that really aren't really enumerated in the Constitution, but yet the court has recognized, and the unshaky ground upon which those decisions still to this day are found. So I think that's the end of my main points, and I'll, leave it up to questions if there are any.
Okay, Professor Roeder, thank you so much for your presentation. You brought us a lot of thoughts and insights. And something called my attention during your presentation. I was reading the comments in the chat, and one called my attention because the student says, it's amazing how American law influences Brazilian law. But anyway, the students will have a chance to ask you questions later on, after Walter and Monica. Okay, so again, thank you so much, and I hope you can come back to talk to PUC Goiás again.
Wonderful, thank you so much.
Thank you so much, professor. Muito bem, pessoal, gostaria de passar a palavra agora para o meu amigo Walter Ross. Walter é o representante, o responsável pelos convênios da Escola de Direito da Universidade de Dayton, no Ohio, e ele vai explicar agora para vocês, os nossos alunos, como funciona essa parceria firmada entre PUC Goiás e Universidade de Dayton, para vocês fazerem um mestrado nos Estados Unidos em 1 ano e meio, 3 anos, 3 semestres somente, e com a possibilidade de, inclusive, de exercer a profissão lá nos Estados Unidos. Walter, thanks again for being with us tonight, and the word is yours. Walter's not here. Será que caiu a internet do pessoal lá, Lucas?
Hello, can you hear me, Paulo?
Yes.
Yes.
Hi, Walter.
My
No problem.
microphone was on mute. I'm sorry.
Okay, the word is yours, Walter. Thank you so much for being here again with us tonight.
Thank you very much, Paulo, and thank you, Chris, for that very, very interesting presentation. My name is Walter Hawes, and I work with Margaret Ioannidis in the international outreach for the Online LLM program. I'm actually here standing in for Margaret this evening because she cannot be with us. But it's important that you know who Margaret is. Margaret is the director for the Online LLM program at the University of Dayton School of Law. Margaret is a licensed lawyer with a JD degree and a master's in science in foreign service from Georgetown University. And Margaret has practiced law in the field of immigration law and taught legal and research writing. And Margaret has worked with Online LLM programs since 2014. A little bit about the background of the University of Dayton before I tell you about the Online LLM program. The school has a 170-year-plus history, and we are recognized as a top-tier university in the United States and among the top, within the top 10 best Catholic universities in the country. We have over 11,000 students enrolled at the university, where more than 1,000 of those students are actually international students. And we're known as a major research university. We're located on the southern border of the city of Dayton in the state of Ohio, which is in the Midwestern section of the United States. And the campus sits on 388 beautiful acres. We are accredited by the North Central Association of Colleges and Secondary Schools. And importantly, we've been accredited by the American Bar Association since 1975, although we have a history with the Bar Association that goes back to 1922. So what is an LLM? It's a Master of Laws. It's a postgraduate degree where in most cases, it's required that you have a first degree in law before you can study the LLM degree. It is a specialized field of study, and it takes about 1 year of full-time study to earn the degree. Now, the University of Dayton's Online LLM degree is an LLM in American and transnational law. And this is a degree that historically students would have completed or do complete on campus in Ohio. But in 2019, we started to offer this program online as a way to take advantage of the technology to make the degree more accessible and more affordable for students to study from all over the world. It is a degree that provides the students with a very strong foundation in US law and legal practice. The primary audience for the degree are foreign educated law graduates. The curriculum consists of 12 courses and a total of 30 credits, and our academic year is broken into 3 semesters, the first beginning in January, the second in May, and the third in August. Students are required to maintain a minimum of 2.2 grade point average, and they must complete their study of the degree within 3 years from the time that they start. For PUC Goiás students, a student can actually begin studying the LLM degree with us as long as they're in at least their 8th semester of their Bacharelado en Direito, and I'm sorry if I pronounced that incorrectly, the course of study. Alumni from PUC Goiás, they may start to study the LLM at any time. The best way, and I'll talk to you about how to reach out to us if you have interest in the program, because we begin the process with a one-on-one video interview. And during that initial interview, we'll have a chance to talk to you in more detail about the possibilities for credit recognition and potential scholarship opportunities. Again, as I mentioned, there are 12 courses that make up the curriculum. 5 of those 12 courses, and those would be the ones that are highlighted in green text here, are required for everybody that studies the degree because those are the key foundational courses to understand US law. As I mentioned, the course is 100% online, asynchronous. Each semester, 4 or 5 classes are offered. And again, those semesters begin in January, May, and August, respectively. And a student can take between 1 and 4 classes each semester. Each course represents between 2 and 4 credits. And each class corresponds to approximately 10 hours of coursework each week. So students can study at their own pace. Highly motivated students can actually complete the degree within 1 year. Those who want to spread it out can, as I mentioned earlier, can take up to 3 years to complete the degree. And importantly, the curriculum is aligned with current requirements for the Washington State and the California bar exams. So students, again, who are interested, as we get into those individual one-on-one interviews, we can go into more depth and detail in explaining to you about the bar programs. Again, the flexible asynchronous format is very user-friendly. This is a screenshot example of the course structure for one of the courses, the Introduction to U.S. Law. This gives you an example of the outline for the different units of the course. You could then drill down on one of the units, and you can see how the platform provides a great amount of detail and guidance for students, because remember, you'll be studying the program at your own pace. On the left, you can see that it gives you the introduction, the information for the different modules, including the reading articles, the video lectures, discussions, etc. In the middle, it's a list of all of the learning objectives for that particular module or that unit, the important dates that you need to know of to keep up with the assignments that are due, and the quiz and exam dates, and a weekly checklist to make sure you're keeping pace with the course. There is also a tremendous opportunity for personal connection with the professors, and they are very accessible. There is, in addition to being able to have office hours by video with professors, each course will have 4 live sessions per class per semester. So even though we say it's 100% asynchronous, there are actually 4 synchronous sessions throughout the semester for each course. There is, in addition to that, an academic success professor who you can reach out to and access in order to understand better how you might put together your strategies to study the materials and or improve your understanding of the materials. In addition to that, we do a number of different online LLM virtual events, similar to webinars like you're participating in today, that you have exclusive access to as a student of the Online LLM program. There are no additional costs involved beyond the regular tuition cost. All of the free reading materials are provided, and they are available online for each course. We also offer free career counseling services through the University of Dayton School of Law's Career Services Office. There are also additional supplemental online resources that include course outlines, practice and multiple choice essay question tests, supplemental lectures, etc., to augment your knowledge on the particular subjects that you're studying. And we provide you with free access to online library resources. Again, that's all included as part of the program. The application process is pretty straightforward. These are a list of the documents that are required to apply. Again, we would walk you through the requirements in the individual video interviews we would do to initiate the process for any interested student. And the way in which you, the completed application forms are usually due about 30 days before the start of the semester. The next semester begins on May 9th. The deadline for a completed application is April 8th, which is right around the corner. There is a little bit of time if anybody is interested to try and begin in the May semester. And the way in which you reach out to us, you can reach out to Margaret directly or myself directly by way of our email addresses here, or certainly feel free to call or send us a text message. And with that, I'd like to introduce Monica Hayes, who's with us today. And Monica is the first graduate from the Online LLM program. Monica is from Sao Paulo and was the first to pass the bar exam and was admitted to the Washington, D.C. bar. Monica is licensed in Brazil and the District of Columbia, and now works as the Assistant Vice President in the Office of the General Counsel for Credit Suisse. So Monica, the floor is yours. Monica?
Hello. I'm not sure if I'm on the live session or not. Can you all see me?
Well, I can hear you, Monica. I can't see you.
Okay, that works too. I'm not sure if all the students are listening to me. Oh, now it's showing it's blue and I am in the show. That's great. I'm not sure why my camera is not showing. I always like to put a face to a name for the students, but I hope everybody's well. And as Walter kindly introduced me, I'm also Brazilian and I graduated in Sao Paulo. And I'm a licensed attorney as well. I still maintain my bar license from Sao Paulo. And oh, great, Laurie, you can see me. That's great. And now I'm licensed here in the US. So I always like to tell you students that are watching us today that as per Walter and Margaret, I'm also available to all of you if you want to clarify any doubts that you might have about the program or about being a foreign attorney in the US, taking that path of the LLM, and then taking the path of passing the bar exam. I speak Portuguese. I can, talk to you using WhatsApp or on a Zoom call. I am at your disposal. I know that when you're thinking about taking that journey, a lot of questions might come around. So I like to put myself out there and be really available to you. I work with Margaret and Walter, assisting with prospective students and also students that are current in the program. So helping them getting a better sense on how to navigate the program, how to better use your time, how to approach the classes and the assignments from a student's perspective, which is hopefully helpful, and also how to prepare yourself to sit for the bar if that's your goal, being that taking the bar exam involves a lot of steps, as you can imagine, similar to Brazil, but in a foreign country, in a foreign language. So I help students with all that process as well. Right now, I'm working for Credit Suisse, as Walter said, so I also give students insights in how to approach the job market here in the United States as a foreign attorney with an LLM or a license, hopefully for all of you, that's also a possibility, with a license here in the US, and how to approach looking for a job or, moving from one country to another, or if that's not what is your goal, how you can better use this program to your benefit. And I think that's all from me, Walter. I'll hand it back to you. If anyone has any questions, of course, I think Professor Paulo will open the floor for questions. So feel free to ask me anything.
Okay, thank you very much, Monica.
Of course.
And at this point, I think we would like to go ahead and open the floor for questions. So I'm going to hand the floor back to Professor Paulo. Thank you, Professor Paulo.
Again tonight. And, pessoal, eu abro agora as perguntas, tá? Né, a nosso webinário aí, para as perguntas que vocês possam ter, tanto para a Mônica, para o Walter, ou para o professor Roder, tá? Palavra é de vocês. E vocês podem mandar as perguntas, enviar as perguntas pelo chat. Tanto sobre o programa de mestrado, né, em parceria PUC Goiás com a Universidade de Dayton, né, ou para a Mônica ou para o professor Roder. Muito bem, acho que nós não temos pergunta. Mônica, você foi bastante clara, o Walter também, e também acho que não temos nenhuma pergunta para o professor Walter. E Walter, você teria alguma pergunta? Walter, would you have any questions to us. Lori?
Hello, Paulo. No, I don't have any specific questions, but thank you.
Okay. I think the audience, the students also have no questions. And but anyway, they have your contacts, they have my contacts also. And if we have any questions along the week or along the next days, I'll pass them over to you. Okay?
Okay, that sounds great. Again, they can reach out to us, as you said, by way of our email or the phone numbers there that were listed.
Okay, great. So I just want to thank you, all of you again, Monica, Walter, Laurie, and Professor Roder, and for being with us tonight. And we have a long way to go this year, and hope to see you again soon. Thank you so much for everything you have done, and PUC Goiás is very happy with this partnership.
Okay, same from us. Paulo, thank you very much, and thank you for all the students that attended, and we look forward to seeing you at the next event.
Thank you very much. Good evening, everybody. E boa noite a todos os nossos alunos, todos os participantes, e qualquer dúvida, estamos à disposição lá no gabinete da reitoria para qualquer resposta ou qualquer dúvida que vocês possam ter em relação a essa parceria. Muito obrigado. Thank you all, everybody. Lucas, muito obrigado. E boa noite a todos. Good evening, everybody.